Everyone. We're just getting started. I'm Bruce Lloyd, GAHE's Executive Director. Welcome to today's BEG MBA Topics webinar series. It's my pleasure to introduce our PEG Physician Executive Group Chair, Boykin Robinson, who is CEO of Core Clinical Partners. Boykin, go ahead and take over.
Absolutely. Good afternoon. Thanks for joining. As Bruce said, I'm Boykin Robinson with Core Clinical Partners. We are a physician services company based in Atlanta. We do emergency medicine, hospital medicine with hospitals all over the country. And the PEG group has last year and this year, last year we started a lecture series with the Physician Executive MBA program from the University of Tennessee, where I got my MBA in 2018. Fantastic program. Today we're going to hear about Stark Law from Professor Zack Buck. Professor Buck specializes in health law at the University of Tennessee College of Law. His scholarship examines the enforcement of laws that affect health and healthcare in the United States. So important stuff for all of us. And so with that, I'll turn it over to Professor Buck.
Thank you so much, Boykin, and thank you all for being here. Happy to spend some time with you this afternoon. And I've been asked to talk about the Stark Law, so specifically an introduction to the Stark Law, some of the general legal parameters that are invoked by the Stark Law, thinking about compliance. And so I'll focus my remarks there. The goal will be to go about 40 minutes or so and leave time for questions at the end, but also throughout the conversation, throughout my remarks, please feel free to use the chat function if you've got questions, and I'd be happy to answer them. This is, meant to be for you all as we talk about these important issues, so I'm happy to stop and answer direct questions. So the Stark Law is, endlessly interesting from my perspective in terms of how it operates on American healthcare, how it changes, how it has changed over time, and what kind of compliance strategies it creates and requires. So what my goals are in the 45 minutes or so I have are to make sure that you understand the general principles of the Stark Law, so the most kind of important doctrinal definitional components of the law, to talk a little bit about exceptions and potential compliance goals and strategies, and then also to walk through an example of a recent case that should be front of mind when you're thinking about these issues. Sometimes the case law method, at least in law school, of course, is heavily used and is a really good way to tease out some of these more complicated doctrines. So when we're talking about the Stark Law, what exactly are we talking about? We're talking about a law that is basically regulates the relationship, the financial relationship of physicians, and particularly does so in a unique way. And what do I mean by that? Well, often the Stark Law is put next to other legal regimes, so the False Claims Act or the Anti-Kickback Statute. And as you're thinking about compliance in these spaces, you have to think about the differences between the two laws. So where the Anti-Kickback Statute, for instance, prevents a bilateral relationship, that is referrals for remuneration, the Stark Law prevents a unidirectional relationship, or at least how I portray it as unidirectional, which is prevents a physician from having a financial relationship for a designated health service that then ends up billing or resulting in a bill that is sent to a federal healthcare program. So the Stark Law, the best way to understand this is, as I talk about it in my MBA, to my MBA students and my JD students, is when you need to prove an AKS violation, you're looking for two parties. In a Stark violation, you may just be looking for one. There is still a requirement to basically a connection to another entity, but in terms of the people who are often ensnared in these, it's one person. Note also here the word at the top of the slide, or near the top of the slide, is physician. That means the Stark Law is limited to applying only to physicians. It does not apply to healthcare providers who are not physicians, which is also an important distinction between other fraud and abuse statutes. Okay, so let's break it down a little bit more. So what does it generally prevent? Well, it forbids a physician from referring to an entity, so that is referring healthcare business or federal healthcare business to an entity for what is called a designated health service or DHS, if the physician has a financial relationship with that entity and the entity itself cannot present to Medicare the claim for payment as a result of that prohibited referral. So there's a potential here for liability both for the physician and for the resulting entity that ends up billing the government for the care here. But for our purposes, we focus on physician liability. So important terms here, of course, referral, designated health service, financial relationship. And I'll talk about all of those here in the next few minutes. The Stark Law also is a prophylactic law in some ways, in that it makes a whole class of referrals illegal and then has carve-outs or exceptions, as they're called, under the Code of Federal Regulations. And these change year over year. They've expanded recently, expanded at the start of 2021, and we'll talk about those. But if you're thinking about Stark in terms of liability, the Stark Law makes illegal, or at least questionably illegal, all sorts of referrals, a whole class of business activity that then is particular business relationships are carved out from liability on the back end. So we often talk about this, at least in the law school, as being within the ambit of the Stark Law, meaning if you are a physician who refers to an entity for a designated health service and you have a financial relationship with that entity, and then you bill Medicare following that service, you are within the ambit of the Stark Law. It doesn't mean you violated it, but it means you must be within an exception to avoid liability, and we'll talk about that. So many students come to me afterwards, particularly PEMBA students that I've had, and say, that sounds like regular business. And you're exactly right. It is regular business in the American healthcare system. We have made a whole class of referrals within the ambit of Stark, and then we carve out different areas of exceptions that allow providers to still, make these referrals, but do it under certain contexts and certain rules. So in other words, it's a broad-based, strict liability statute with exceptions. One piece missing here that we talk a lot about in the law school is there's no intent standard, right? So the physician does not have to know that she is violating the Stark Law or that the Stark Law even exists. There is no intent requirement in order to prove a violation of Stark, which is what makes Stark so scary for a lot of providers. So what is the specific language? And this is within the Medicare statute. If a physician or an immediate family member of such physician has a financial relationship with an entity, then the physician may not make a referral to the entity for the furnishing of designated health services for which payment otherwise may be made under the subchapter. And then, of course, there's entity liability as well. So I've underlined the key component pieces here: physician, financial relationship, referral, and designated health services. And we'll go through those here in the next few minutes. If you're building a case, that is, if you're a federal prosecutor or you work for OIG and you're thinking about whether or not there's been a Stark violation, you're going to focus on these four main elements. Does the individual have a medical license? Is there a designated health service at issue? Is there a provable financial relationship? Has there been a referral? And then, of course, on the back end, you ask, is there an exception that makes this type of behavior allowed? Again, why do we have the Stark Law? Well, you can dive into the regs. At the time we adopted the Stark Law in the 1990s, but the concern was for overutilization and for conflict of interest here, right? So this is a law that's modeled off of Florida's law and named for Pete Stark, who's a former official congressman from the state of Florida. And basically the federal government Congress used the Florida Stark Law as a guide and passed it in the early 1990s. We've then had two more iterations of the Stark Law that have followed in the last 30 years or so. And then, of course, as I mentioned, exceptions that have continued to be added over the last 3 decades. So let's talk about financial relationship. What does that mean? So financial relationship under terms of the statute can be defined as basically one of 2 different types of relationships. The first is what's called an ownership or investment interest, and the second is called a compensation arrangement. Most important for our purposes, at least as it applies to physicians today, is a compensation arrangement. What is that? Well, a compensation arrangement has been defined as any arrangement involving remuneration between a physician or his or her family member and an entity. This remuneration can be overt or covert. It can be paid in cash or in kind. It can be direct or indirect. It can go through a secondary party as well. There are differences between the direct remuneration and indirect remuneration, which we can talk about in the Q&A if you have questions. But the most important thing to understand here is any type of financial relationship, typically compensation arrangement, and it can be of any type of compensation, satisfies this element under the Stark Law. So if the physician receives anything of value from an entity, either in cash or in kind, this satisfies the financial relationship prong. An important caveat here, or important emphasis here, this includes not just cash or funding, of course, but also discounts. So if you are an individual who gets a discount, or you're leasing property from an individual, from an entity, and the entity charges you, gives you a discount for that rent or that lease, that also satisfies the financial relationship prong under the Stark Law. If you have an indirect financial relationship, the feds and OIG officials, as well as federal prosecutors, will look at whether or not there is some form of intent here. So the way Stark is structured is if you have a direct financial relationship, so that is if you are employed, let's say by a hospital, you have a direct financial relationship. If, however, you have multiple entities between the first actor or the first entity and yourself as the physician, then the feds will basically look to see whether or not the institution itself has some awareness that there is a ownership, or that there is a compensation arrangement between those two parties, so that if money is flowing through lots of different entities, there is a little bit more of a burden for the federal prosecutors to prove in these cases, as opposed to a direct financial relationship. Still, in these cases, financial relationship often is not a hard proof. So that means that in many of these cases, as long as you can prove something of value is sent from the entity to the physician, then you've satisfied this requirement. Here are some examples. So an independent physician compensated for a physical exam on hospital employees. So this physician is not employed by the hospital, but is contracted with by the hospital to perform physical examinations on all types of hospital employees. Here, this would be a financial relationship. If the compensation goes from the hospital to the independent physician here, absent availability of an exception, which of course is what we'll talk about toward the end of the hour, the physician could not refer Medicare patients to the hospital for designated health services, or else the physician would find themselves within the ambit of the Stark Law. Another example. Again, the hypotheticals sometimes are the easiest way to understand these laws, and sometimes they are a little absurd, but it's good to push on some of the doctrine here to understand it. So if a physician owns a 1% interest in a restaurant, and that restaurant is contracted with to cater board of director meetings at the hospital, that physician has a compensation arrangement with the hospital, despite the fact that the compensation paid to the restaurant does not relate to a DHS or Medicare or Medicaid. And again, absent an exception, the physician cannot refer Medicare patients to the hospital for a designated health service. So what does this example show us? It shows us that the financial relationship does not have to relate to healthcare. It does not have to have any kind of relationship with designated health service, Medicare or Medicaid, or any kind of healthcare service. Once you're able to show any financial relationship, then you've satisfied this requirement. Of course, you'd still have to show referral, you'd still have to show designated health service, but in terms of isolating the financial relationship category, this hypothetical would satisfy that.
Hey, Zach, how does that change if a physician's spouse has that 1% interest?
Great question. It's almost like
I did not look at your slides. Right.
Great question. So we'll talk about that when we get to physician, but generally, the rules are any immediate family member is treated as the physician.
Okay.
Right? So if
I
your
assume
spouse,
so. But,
yeah. We'll talk about that. There's some interesting line drawing exercises on the definition of physician or immediate family member when we get to that point. Thanks for the question. Any other questions on financial relationship? Great. Okay, so the second piece of this that I'm going to talk about is referral. So what is a referral? Referral is any request by a physician for an item or service for which payment may be made under Medicare, and to a limited extent to Medicaid. This includes consultations with other physicians, as well as any test or procedure ordered by the other physician. And the key piece here, which is always something that is difficult for my law students to wrap their heads around, is at the time of the referral, the physician does not have to know whether the referral will result in any service. So again, this goes back to Stark, lacking an intent standard. Because Stark has no requirement of intent, that is recklessness or knowledge that an individual is breaking the law. This is a key component piece to most criminal laws. We require intent. Because Stark does not have that, the federal prosecutors do not have to prove that the physician who made the referral knew or didn't know that that referral would ultimately result in some bill that would be sent to Medicare. So again, if you are a physician who are basically referring or basically sending patients to get additional care, and you don't know whether or not that is going to result in any bill that's sent to Medicare toward the, eventually down the line, that will not save you as a defense against potentially violating the Stark statute. So again, two kind of key pieces here. First, financial relationship can be any financial relationship. It doesn't have to be related to healthcare. And secondly, on referral, you don't have to know that the referral will end up resulting in any federally reimbursed healthcare business at the time you make the referral. It still counts. And that goes back, like I said, to the intent standard. So here's an example. So physician A, a primary care physician and an owner of medical group A, asks physician B, an orthopedic surgeon with a separate practice, to provide a consultation regarding a knee injury one of his patients has suffered. Following the consultation, physician B orders an MRI scan of the knee from medical group A. Physician A is considered to have made a referral to medical group A for the MRI scan, and thus the Stark bill is violated unless, of course, an exception applies. So just taking that apart for just a minute, Dr. A is sending business to whom? Medical group A. Dr. A is referring his patient to an entity in which he has a financial interest. Why? Because he owns medical group A. Again, did he know at the time that he sent his patient to physician B that it would eventually result in business for medical group A? There's no evidence of that here, but it's not a question that we have to ask because it's not a required showing under the Stark law. So even if you begin the chain of referral and you don't know necessarily where that care will end up, as long as that care ends up benefiting an entity that you have a financial interest in, the showing of referral will be made. Okay, questions at all on that one? Okay, so let's move on to physician. So this goes right to Boykin's question. So physician is not defined in the Medicare regulations and the CFR, but comments do give you some clarity here. Physician is generally treated as being in accordance with the definition of physician generally used for purposes of the Medicare program. So that includes, of course, licensed physicians, osteopaths, oral surgeons, dentists, podiatrists, optometrists, chiropractors as well. This usually is not an issue when we're dealing with the Stark law. Again, physicians are those who are the main entity or main individuals who are regulated by the Stark law, but also we have entities that can be liable under Stark as well, if of course they are the entity that's billing Medicare for business that is related to a banned referral under the Stark Law itself.
Hi, Zach. Good afternoon. This is Lewis Simmons. I have a quick question.
Sure.
Under that listing of providers, it does say physician, but I had a question about other licensed independent practitioners. So, for example, in our organization, we have behavioral health specialists, such as licensed clinical social workers, nurse practitioners, et cetera. Even though I know this is specifically for physicians, and what you listed here are independent practitioners. But are those providers included under the definition of physician since they are a provider?
Great question. For Stark Law purposes, the answer is no.
Okay, that's what I thought. Okay.
Yeah, so Stark has, as do most health law, fraud and abuse statutes, somewhat bizarre and indefensible boundaries where the result of the legislative process have kind of created kind of bizarre ends of the road or guardrails that we put in place. When you're thinking about these from a policy perspective, does it make sense to limit this law just to physicians when you've got individuals with prescriptive authority or who see patients individually, like nurse practitioners or ANPs? Probably not. From a policy perspective, does that make sense? But Congress has never gone back to widen the definition of the statute itself. So we're dealing with what they created in the 1990s. So those individuals would not be covered by the Stark Law. However, the other statutes that govern fraud and abuse, they absolutely are subject to those. So the anti-kickback statute has no limitation on the identity of the provider. So nurses can violate the anti-kickback statute, LCSWs can violate, techs can violate, PAs can violate. That's all anti-kickback. The requirements of that statute are a little bit different. They require intent, but it's similar in structure. It's, a kickback, it's something of remuneration sent one direction for patients in the other direction. So you often have quite an overlap between Stark and anti-kickback interventions. As for purposes of Stark specifically, though, non-physicians are not the target of the Stark Law. Good question, thanks. Anybody else? Okay, so to get to Boykin's question, here's the immediate family members. Again, this is from the regs. So it includes spouses, parents, any step, parent, child, or sibling relationship, as well as any in-law relationship. The regs are a little bit confusing on grandparent, grandchild, which is why I put it in parentheses, but most sources you read include grandparent and grandchildren relationships, which include, of course, any step-grandparent or step-grandchild relationship or any in-law relationship, which is related to those relationships as well. So if you ever have a question about whether a family member counts for purposes of Stark Law as a physician because you have the same kind of financial interest, typically the answer is yes. The only limitation, clear limitations we have from the regs are any cousins or aunts or uncles that are not included as part of an immediate family member. So how about an example? An orthopedic surgeon's grandson's wife, right, is a physical therapist, and the surgeon would like to tell one of his patients that he or she should visit his grandson's wife for physical therapy. Stark Bill prohibits that physician from referring patients to his granddaughter-in-law's practice since ownership will be attributed to the physician. So what happens in these cases is if you have an immediate family member who you're referring business to, that ownership or compensation arrangement or interest will be imputed or attributed to you as the physician. No exception available, this will violate Stark. We'll talk about in some cases there could be an exception available, but in the facts I give you here, there's not. Second example, physician writes a prescription for a medication and recommends a particular pharmacy. Patient goes to that pharmacy. One of the 10 partners in a partnership that own and operate the pharmacy is the physician's stepson. The physician has made a referral to the pharmacy and has violated Stark. This hypothetical has actually been adopted somewhat. It's based on a real investigation. And in the facts in that case are even more attenuated because there is no, and I don't mean this to confuse everybody or scare everybody, but because there's no intent requirement in the Stark law, there have been cases where the doctor asks the patient to get their prescription filled, does not necessarily make a recommendation of a particular pharmacy, but the patient ends up choosing a pharmacy that is owned by an immediate family member of the doctor. And that has still triggered an investigation. Most physicians that I talk to say, how could I ever avoid that? What do you recommend that we say to our patients? Do we say they have to avoid a particular pharmacy because they know that they have an immediate family member who has an ownership interest in the pharmacy? I don't think you have to go that far. I think this is kind of the high watermark of Stark investigations. And I think there were other things happening in that case that led to that investigation. So it on its own, without recommending a particular pharmacy, would not be enough to draw scrutiny. But still, you have to be careful again about, because there's no intent requirement. It really just comes down to what ends up happening, right? If you end up telling a patient they've got to go get a DHS somewhere and they end up going somewhere where you have a financial interest or you have an immediate family member who has a financial interest, the federal prosecutors can put that puzzle together in a way on the back end to make it look like that was something you knew and something that benefited you financially. So you have to be careful when you're thinking about this. There are exceptions, of course, for rural areas and for academic medical centers and all sorts of other things. So it doesn't necessarily mean that you're violating Stark, but again, you could be within the ambit of Stark, which is, again, not a very comfortable place to be if you're thinking about risk. The final category I'll mention here, or the final element, is designated health services. So again, going back to Lewis's question that was asked, right? Designated health services, another place where the Stark law draws lines. And you may think that there's lines here that don't make a whole lot of sense. So we have different iterations of Stark where the definition of designated health services shifted over time. So Stark 1, which was the first iteration, of course, of Stark in the early 90s, only applied to clinical lab services because that's where the feds were seeing a lot of referral business. Stark 2 then expanded the scope of Stark to apply to other areas of the medical industry, including physical therapy, occupational therapy, radiology, radiation therapy, DMEs, IVs, prosthetics, orthotics, and prosthetic devices, of course. There are others that have also made this list: home health, outpatient prescription drugs, and inpatient and outpatient hospital services. So Stark has quite a broad reach if we're looking at the definition of designated health services. There have been particularly specific areas that have been carved out of designated health services, and you can see some of the examples here. Again, I don't have a whole lot of information as to why the lines have been drawn here, but again, we can think about the role of lobbying, the role of kind of PR, the role that of individuals who have interests in the industry, and where we see most fraud or most overutilization. And so we can speculate as to why some of these are DHS services and some are not. So, yeah, go ahead.
Zach, are just straight pro fee services performed by physicians, those are not DHS, at least I'm not. And when you say inpatient, outpatient hospital services, that's the hospital fee or the technical fee, right? But never the pro fee.
That's right. Thank you.
You can consult a partner.
Correct. Thank you for clarifying. Yes. Any other questions on the DHS? Right. So the key 4 components that you want to think about, of course, if you're thinking about Stark: financial relationship, physician, referral, DHS. You have to have all 4. If you don't have 4, you're not within the ambit of Stark. If I refer a patient to my spouse's, clinic for an ultrasound procedure that involves the insertion of a needle, I'm not worried about Stark. Even if I make that referral knowing that that could result in business. So again, it's an example of where the lines have been drawn, and sometimes they make sense and sometimes they don't. Again, you have to be worried about other potential risk mitigation beyond Stark in some contexts, and most specifically anti-kickback. But nonetheless, we still draw lines, in certain places. let's spend a little bit of time. I know it's a little after half past, talking about exceptions. So as I mentioned, just because you're within the ambit of the Stark Law is not any type of moment to panic. Many, in fact, almost all business arrangements in American healthcare are within the ambit of Stark Law, as long as it's a designated health service. Right? Anytime a physician is employed by a clinic, that's a financial relationship. That's a physician with a referral, of course, involved with a financial relationship, and then utilizing designated health services. So you're within the ambit of Stark. So then the question becomes, how do you fit within an exception? And this is the job of your in-house counsel, to make sure that all the T's are crossed, all the I's are dotted, to make sure that you fit clearly and squarely within an exception. Stark is not the only federal statute that is structured in this way. The anti-kickback statute has the exact same structure. So anti-kickback, again, makes a whole host of business arrangements illegal or presumptively illegal, and then carves out islands within that space of safety. Those are called safe harbors. In Stark, we call them exceptions. There's a lot of crossover between both. So if you meet one, you likely meet the other. You don't have to worry about Stark liability if you're not worried about anti-kickback liability. There are three types of exceptions within the Stark Law: general, ownership, and compensation. And I'll give you some examples of each of these over the next few minutes. So in terms of general exceptions, what are these, or what are the most frequently used? Well, physician services that are incident to and furnished personally by another physician who is a member of the referring physician's group practice, or is a physician in the same group practice, or supervised by one in that practice. What exactly does that mean? That means that if I have a group practice with a partner and my patient who I see also gets some kind of medical service or consultation from that partner, we have not violated Stark, because there is an exception for physician services that are incident to, as long as we're in the same group practice. So again, this allows collaboration, it incentivizes it, and of course we know that's really important, and so it wouldn't make sense to make those types of incidental types of care offered subject to the Stark Law. Additionally, in-office ancillary services, very similar, right? Must be furnished by a referring physician or a member of the same group, and be furnished in one of two locations and meet these location-specific conditions. Again, if you have concerns about some of these questions, you'd want to consult an attorney so they can go deeper into the regs here. These are just very surface level to give you an idea of kind of how they operate. But again, you're not going to be the target of an investigation if you fit within an exception here. Here, these are the two general exceptions that I give you. Here's some more. Preventive services, right? Preventive services are not subject to Stark regulation. That includes vaccines, screening tests as well. Rural patients, again, another exception here. If it's infeasible, right, for the patient to receive services any other way based on geographic limitations, again, protected. And the academic medical center exception. This allows referrals between a faculty member and the university hospital. Of course, there are a number of best business practices that are raised here by the academic medical center exception, which are also raised by other exceptions, which I'll talk about here in just a minute. But to give you a preview, fair market value is an important piece, a contract that's set in advance, and that the fact that the entity or the physician does not take into account the volume or value of referrals of the patients that they will see. So those are the selected general exceptions that I run through. I know I have a couple of duplications here. The second type of exceptions are ownership exceptions. And these are, again, exceptions for physicians who have a concern about a financial relationship based on an ownership interest. So if you have an investment security, if you own stock in a company that is publicly traded, but you also refer patients to that company or to that hospital or to that entity, you are exempt from Stark liability, because we think that that's different than having a direct financial relationship that is private instead of ownership of a public investment. Ownership of a whole hospital has an exception here. Ownerships of hospitals in Puerto Rico So again, you can see examples of how law is made in this space and where the lines are drawn in certain cases. Of course, we could get underneath and ask why that is, why the policy has been drawn the way that it has been, but I just give you this for illustrative purposes. The final type of exception are compensation agreement exceptions, and these are probably, at least in my practice before I went into teaching, were the most important and the most common exceptions in the Stark Law. So these include space and equipment leases, employment, personal services arrangements, and fair market value compensation. I'm going to pause here for just a minute because these are so important. So because these are all of the same kind of exception, they all require similar showings. Most of them require 4 to 6 elements that your in-house counsel or attorney would have to be aware of and make sure that your entity and you yourself, if you're employed there, follows all of these rules to make sure that you're within the exception. So again, all of these come down to contractual execution. So the entity and the physician have to enter into a contract for at least 1 year. It has to refer to legitimate business purposes. If it's involving rent or space lease, it has to be set in advance at fair market value. That means you have to engage a third-party entity, maybe an independent review organization, or a certain financial advisors, Price Waterhouse, Deloitte, to run a study on what fair market value is to make sure you're within that range. You cannot take into account the volume or value of referrals or the business that is generated by the relationship, and terms must be commercially reasonable. They must have been negotiated in good faith at arm's length, and there must be evidence that the parties were operating honestly and transparently with one another. Same thing with employment. So you might have been thinking, as I was walking through this, if you're employed at a hospital, you have a financial relationship with the hospital. You are referring patients to the hospital for other services. You are a physician, right? And you're probably engaged in designated health services. So you think, anytime I'm employed anywhere and I'm sending patients across the hall or to radiology, I could be violating the Stark Law. The answer is yes. The reason that you don't is because there's an employment exception. And that means you must have an employment contract that you've signed that sets out identifiable services, that's consistent with fair market value. You're not being overpaid in any way based on what the market would suggest. It can't take into account the volume or value of referrals, and it must be commercially reasonable. That is, the hospital cannot pay you more for more referrals that you give it. It has to be set in advance. Oftentimes salaries are the best way to go here, as we talk about it in the PEMBA class. Other examples of compensation agreement exceptions include personal services arrangements. So these are for individuals who are not directly employed by entities, but they are independent contractors and they're engaged in much of the same work. It's kind of the same exception here, it's just a few technical differences. And then you have the catch-all, the fair market value compensation exception, which basically says the feds say, hey, even if you don't fit within any of these previous exceptions, as long as you're given fair market value compensation, there's a specific document that says what you're supposed to do, it's in writing, it's signed, then we're going to allow you to do it. So again, the concern here from the federal government is, are you living up to your contract? Are you doing specific healthcare services that you said you would do? And are you getting paid an appropriate rate, not overpaid, based on fair market value? That's where the federal regulators will be looking.
Zach, I have a question around fair market value.
Sure.
In this case, but maybe even broader. So someone does a study to say what a physician should be paid in a certain situation.
Yeah.
But if for whatever reason, some bump in the market, COVID, some temporary shortage is causing rates to be much higher than, if community rates are much higher, or for whatever reason, you just can't, on my side, I'll contract with a hospital to recruit docs, but then if I can't recruit docs other than at a higher number, my argument is, well, this is the market. What else would I do? But how do you square that with someone who's not actively doing it themselves, telling you what the market should be?
It's a great question. So most of my experience working with in-house counsel, I used to have engaged somebody who I actually taught in Georgia and would have a in-house counsel from one of the big Atlanta hospitals come and talk, and he was responsible for maintaining employment contracts. And he actually said every 6 months you should be updating these. You should be engaging a third-party independent review organization to update the fair market value number. Now, of course, that might be best practice. I think a lot of rural entities probably don't have the resources to do that if they don't have a lot of compliance staff. But that should, right, theoretically catch market jumps, particularly swings that are rapid. It may not capture everything. And so most of the time, at least when I would see these documents in practice, there'd be a range. And so you really advise the client, the hospital, to make sure they're within the range. They could be toward the top end of the range. That's okay. But anytime you're outside of it, it almost becomes presumptive, not presumptively illegal, but presumptively it creates a scenario where the hospital is going to get a second look from the feds. So if you make sure, and what he would say too, is he would say, I get these reports from Deloitte or PwC, whoever it was, and I staple them to the employment contract. And so if we ever get audited or we have a federal regulator knocking on the door that says, I need to see this employment contract, then I can pull that out.
And does that apply? That makes sense for long-term employment contracts.
Right.
Are there exceptions around, physician gets sick and needs to be replaced on schedule, and your choices are pay well over FMV or not provide the service?
Yeah, that's a really good question. So Stark is very skeptical of engagements that are short term because, at the time that Stark was passed, there was a real concern that a lot of overutilization, conflict of interest, fraud was occurring, where individual entities were engaging physicians for a day, a week, a month, and then overpaying, basically a sham contract, just to get the referral source that they wanted or to establish a relationship. So that's something that your attorney or in-house counsel would have to balance that risk. A lot of these issues are not black and white. None of them are.
Yeah, sure.
So the question is, do you want to slide in one direction down the spectrum or toward the other end? And can the attorney mitigate your risk in some way? So is there a way you can somehow structure it? Because a lot of these, so like personal service arrangements, right, requires the contract to be in effect for at least 1 year for that reason. So can you in some way structure it so it does meet that requirement? Or is there some other exception you can fit through that doesn't have that 1 year requirement? Yeah, it's a great question. That's, again, where the rubber meets the road, right? And then on top of that, the question becomes, enforcement of these types of rules, right? Like it doesn't take much for somebody to pick up the phone, and then you've got regulators doing an audit, or particularly with Medicare cost reports that AUSAs have, it's very easy to see if there's some issue that they should look at askance. So that's the exception piece. Yeah, please.
This is Lewis Simmons again. So sometimes the government will lump other profit health centers together with rural health care center rules.
Yeah.
So I noticed in the previous slide, you had said that one of the exceptions is rural healthcare. So does F2HCs fall into that RHC bucket, or is this still separate? It's because it says rural patients, and typically that's where you get into RHCs, rural health centers. So
Yeah.
I have a question about that. If that exception is extended to federally qualified health centers.
Great question. So there's kind of two layers to it. The first technical answer is it applies to rural patients. It does not apply to the rural entity. And my understanding is that's why it's structured in that way, so that it prevents entities from kind of piggybacking onto some kind of exception that would provide cover. So that's the first answer, is no, it would just be subject to patients here. The second layer is a little bit more of like where health law, fraud, and abuse becomes an art and not quite a science, which is, these laws and rules are enforced by OIG, of course, but then they are often, those carrying the football are the Department of Justice. And many times there is a very extensive balancing test done at the front end of these types of cases to determine at the DOJ whether it's worth it, whether it's a case worth pursuing. And in my experience, this isn't always the case, but that in my experience, the Department of Justice is aware of access challenges in these cases and is going to, I would say, and I would hope, be more hesitant to target an entity that has, whose prosecution could result in major access challenges for the patient population in a given area than a hospital that has less of those concerns. So again, that's kind of the art science example. It's not reflected in the statute at all. It doesn't make you sleep better at night, but the DOJ is thinking about that. And I know that people there are thinking about rural access challenges and thinking about enforcing the laws. Of course, on the other end of the spectrum, you have the argument that, which I've been made to me many times, which is just because it's a rural hospital doesn't mean we shouldn't enforce these rules. And what does that do to patient care in those areas, right? So I understand that too. And again, it comes back to this conflict that we deal with in health law all the time between quality and access, right? If you're going to enforce the rules around quality or enforce the rules around Stark that has a negative impact on access, is that worth the trade? Or is it worth to lean more toward protecting access and let a few things go? Stark has that kind of in its DNA with this rural patient exception, but technically, in terms of the hospital front, it's not in the regs. Good question. I know. I know we're down to about 10 minutes, so I'm going to finish up quickly here. So penalties, different than this, the anti-kickback statute. Penalties here are payment denial or refund. There's also a payment ban that can follow Stark findings of liability. Again, because there's no intent requirement, many of these cases are difficult to defend if you've got a paper trail. Additionally, the feds can impose civil monetary penalties, and these are deployed when there is intent. So if the physician does know or should know that this payment is the result of a prohibited referral under Stark, CMPs will be deployed, and these can add up very quickly. They also can be applied to the entity that submits the bill as well as the referring physician. Of course, if you have intent in a Stark case, you have to be worried that you might also be in the realm of the False Claims Act. So if you bill the government while violating Stark and the government would not have paid the claim but for the fraud, that is a kind of requirement of the FCA, and you have an intent standard, that is you knowingly bill the government knowing that there's a Stark violation kind of within this bill or episode of care, then you could have also a False Claims Act type case. So we've seen that actually play out where the hospital will bill knowing or should have known that the bills are reflective of a violation of anti-kickback or Stark, and then those bills get translated basically into a false claim. And that's where the government can really come down with a big hammer. So once you start violating Stark and then you're billing the government, as long as if you have intent in these cases, you do have something to worry about. Differences between the anti-kickback and the Stark law, again, the major differences are on intent, on the identity of the violator, whether it's anyone in the healthcare program or a physician, and the penalty. Anti-kickback carries with it criminal penalties. The Stark law is only civil or almost administrative. Basically, CMS is saying, give us our money back, and you do, and usually you don't face a civil monetary penalty. But again, you have to be careful here if you've got any kind of knowledge. Other noteworthy exceptions and characteristics here, whether you're an academic medical center, you have wide protection, temporary non-compliance. So this is where the entity knows that there's some violation here and it's trying to remedy. Maybe there was an error in billing, maybe there was some contractual error, kind of a technical violation. There are ways to remedy those problems and get basically OIG to kind of pause. There's also been a ton of movement on value-based care. So the newest exception, or one of the 3 newest exceptions, focuses on value-based care, including ACOs and Medicare shared savings. And so if you're in one of those organized entities, you have additional protection under Stark. These exceptions are quite broad. And so entities that are engaged in kind of the forefront of value-based care, as well as accountable care organizations, have seen protection there. In terms of repayment, usually the Stark clock is, this is kind of like a statute of limitations that CMS will allow, basically will go back as much as 6 years to look at potential Stark violations. And then there's also the self-disclosure protocol here, which is something that was around, of course, when I was in practice. And this is always a determination that is made at the time. If you're an entity that discovers a potential Stark violation, is it worth self-disclosure? I think most of the time it is, although there have been the cases where the feds use that self-disclosure as kind of the first step into a major investigation, of course, depending on what type of wrongdoing that self-disclosure protocol uncovers or suggests occurred. So these are kind of the main exceptions. There's also a big case that I was going to talk about. I know we're down to just a minute or two. Let me just highlight the big holding here, and that is, if people have heard of Toomey, this is a case from South Carolina. What is the piece that is important here? So this was Stark, False Claims Act, and a jury trial that ended up in a $237 million fine. What is it important to, or what are you thinking about, I guess, when you're thinking about Toomey? And when can you fall afoul of Stark? Bonuses. Bonuses are a huge regulatory risk area for hospitals. And why is that? Because bonuses often reflect financial remuneration that is not set in advance, right? That is subject to different kind of metrics. And if you are a hospital or an entity that is going to pay a bonus based on volume or value of referrals, you have a major problem. And that's what Toomey did. It paid bonuses to physicians based on productivity, also based on the amount of profitability that the hospital had been able to achieve. So I always tell individuals who are in this space, if you want to pay on bonuses, you got to make sure they're specified up front what you're paying, and you have to use quality as a metric. At least that's best practices, instead of productivity. Because anytime you're paying on productivity, the feds can always say you're paying based on volume of referrals, and that is directly violative of Stark because it takes you out of the exceptions. It also takes you out of any exception you could have for anti-kickback too. So you have to be very careful about physician remuneration and specifically bonuses and how they're structured. So that'll be a big piece I'll stop with. Yeah, Lewis.
And Zach, that would include it seems like tons and tons and tons of physicians are on WRVU type arrangements. Are you saying all of those run the risk of being considered? Because that's by definition volume. I mean, volume's a part of it.
Yeah, I mean, again, we're trying to move clients towards safety, right? So we're shifting people down the spectrum. So it depends on what exactly the WRVU is based on and how that entity specifically has shaped the program. Of course, if you've got fair market value that supports that, if you've got a contract for a year that's in writing and signed and specifies, you're in better shape. Toomey also had other particular problems that also led feds to really want to look under the hood there, including pressure on physicians to perform outpatient surgeries in certain ways, and also to basically directly remunerate physicians based on profitability, which was a huge issue. But the question is a good one and remains open. If you've got a physician that you're paying based on, if you're basing some form of remuneration on business, on volume, how do you avoid this type of scrutiny? Always, I suggest, right, for people to think about quality metrics instead of just volume. Or if there are ways that you can measure volume that do not relate directly to specific referrals.
So, and Zach, actually, that's what I was about to ask, because in certain agreements, I've seen it to where that it's not only based, that the bonus is not only based on, let's say, work RVUs, but what's included in that are, quality metrics as well as efficiency metrics. So from a from start perspective, if you have, let's say, a dashboard that has specific targets, and even though one of them happens to be work overuse, for example, is that okay that you have a number of qualifiers that need to be, met in order for them to get a bonus, not just on work overuse?
Yeah, that's better, right? So one of the problems with TUMI is a huge chunk of, or not a huge chunk, but a component piece of the bonus structure was directly tied to productivity alone. And it was directly tied to profitability. There was no secondary accounting for quality. So that is best practice. If you're going to award bonuses, maybe you have a flat bonus available to people who achieve, certain RVU, but the component piece that separates or differentiates individuals is quality. Again, this is where the art and science conflict, right? Where the feds are going to be comparing hospitals against each other to look to see where which hospital's in better shape in terms of risk mitigation. And so TUMI had a whole lot of missteps in terms of structuring the bonus arrangement. But I always tell, individuals when we're talking about this stuff, to the extent you can structure these like salaries as much as you can, or if you're going to differentiate, you do it based on quality, those are safer.
Zach, is there any difference? I get like surgeons at TUMI, for example.
Yeah.
They're referring patients for surgeries at the hospital.
Yes.
So I understand why there's such a then stark conflict there. Compare that to, say, hospitalists and emergency physicians who are just seeing the patients who are there.
Yeah.
They're not bringing in anyone new. Does all of this stark stuff go away, or do you still have to worry about volume and value?
It's a great question. So the difference, of course, that you're giving me is, does the person going 62 in a 55 on the highway have to worry about getting pulled over as much as the person going 85 in the 55, right? And the answer is no. There's nothing legally that differentiates that behavior, but in terms of everything else, like the optics and the power that the surgeon has to direct business is totally different than the hospitalist that you referenced, right? So if I'm a DOJ AUSA, you know where I'm going to be looking, assistant U.S. attorney. I'm going to be looking at the surgeon, and that's exactly what TUMI shows us.
Okay.
But, right, so in terms of risk mitigation, I'm more worried about the surgeon in that case. Does that